My lady. May I begin, please, at the point of acting on the invitation of Wilson yesterday to look at the Advocate General opinion in proceedings brought by A. The case is Bundle 3, tab 27, and the page I'm about to turn to is MS 1484. Advocate General Cockart sets out at paragraph 41, and there following some uncontroversial principles, certainly from the current perspective, to distinguish habitual residence from mere temporary presence. Residence must normally be of a certain duration. The question there of the important social and familial factors are set out. It needn't be uninterrupted. We read at paragraph 42, and at paragraph 43, in the case of a lawful move, habitual residence can shift to the new state even after a very short period. And the logic the Advocate General calls on to come to that conclusion is Article 9, which of course provides that continuing jurisdiction will vest in the original state for 3 months for the purposes of modification of a judgment, therefore necessarily contemplating that habitual residence could have shifted in that time. Paragraph 45 is the paragraph to which I was referred by Lord Wilson yesterday, in which the Advocate General sets out the opinion that it's conceivable in exceptional cases that during a transitional stage there will no longer be habitual residence in the former state, while the status in a new state has not yet crystallised into habitual residence. And as I indicated, we accept that absolutely as accurate, subject only to raising the query we mentioned yesterday that the word exceptional there we don't think is a test, but simply a recording either of the fact that it will be an exception or a prediction of its likely frequency. The judgment, insofar as it deals with these questions, does so at page 1496. At paragraphs 37 and following. At 37, the habitual residence of a child must be established on the basis of all the circumstances. At paragraph 40, the judgment refers back to paragraph 44 of the Advocate General's opinion, indicating that a parent's intention, the parent's plural intention, to settle permanently with the child in another member state, manifested by certain tangible steps, such as the purchase or lease of a residence in the host member state, may constitute an indicator of the transfer of the habitual residence. 2 points to note there. First, we would draw attention to that as being applicable in the current case. Second, of course, use of the noun there, transfer, potentially indicating that the judgment contemplated a move from one state to the other without a transition. That said, though, at paragraph 43, after having referred back to paragraphs 38 to 41, the judgment sets out that it is conceivable that at the end of the assessment, it is impossible to establish the member state in which the child has his habitual residence. We would say that is the authentic statement of the law, but then, of course, that is again described as an exceptional case in the next sentence.
I mean, the wording of the court's 43 is slightly different from the wording of the Advocate General's 45, but you probably accept that it is meant to be, in effect, a restatement of what the Advocate General had said.
In effect, yes. Perhaps
look at the word conceivable, look at the word exceptional. They're picking up those adjectives, and in their own way, they are repeating 45.
Yes, it may be that the subtle difference reflects, in fact, the way my Lord Sumption put it yesterday, which is that the test, as it were, is applied to each of the two contenders for habitual residence status. And if after that, so at the end of that assessment, then it may be impossible to attribute to either of them the status as a state of habitual residence.
I don't see how it can be regarded as a test at all if a test means some principle on which one is to decide this particular issue, because on the face of it, it is, in your words, a prediction as to how often this is in practice likely to happen, and the prediction may or may not turn out to be right, depending on how often the facts justify it.
Lord, we agree entirely with that. My use of the word test was meant to refer to the principal test of habitual residence, and if having applied that rigorously to each of the two contenders, there is no state, then that's the answer. And it doesn't matter, for the reason set out, that the regulation allows then for jurisdiction to vest in the state in which the child is present. These matters were then revisited in the case of Mecredy and Chaff, which appears at the previous tab in the bundle, starting at page 1468. Paragraph 50, we read that the court has stated the intention of the person with parental responsibility, so differently to the plural parents there, to settle permanently with the child in another member state, manifested by certain tangible steps, such as the purchase or rental of accommodation in the host member state, may constitute an indicator of the transfer, same word again, of the habitual residence, refers back to proceedings brought by A. The necessity for a degree of permanence is set out in paragraph 51, although the reader is reminded that the regulation lays down no minimum duration. 52, the relevance of the child's age is recorded. At 53, the statement is set out that the factors to be taken into account in the case of a child of school age are different to those of a child who's left school, different yet again, self-evidently from those of an infant. And we set out in our written case our assertion that though of school age, B is only just of school age, and her environment, looking at the next paragraph 54, we would say is that of a young child, and essentially a family environment determined by the reference person or persons with whom the child lives, by whom the child is in fact looked after and taken care of. Paragraph 54 applies to a young child, even more so 55 when the child is an infant. This court came to consider these questions, of course, in A and A, which we find bundle 6, tab 65. MS 2535. Is the first passage to which we draw attention for current purposes. My Lady Baroness Hale, having set out the words of Lord Brandon from Reed J in the first half of the paragraph, says the following: I share Lord Hughes' view that the third and fourth points made by Lord Brandon are best seen as helpful generalisations of fact, which will usually but not invariably be true, rather than as propositions of law. There's been a tendency to construe this fourth statement as if it were a statute and debate the meaning of appreciable time. I would not accept that it is possible to become habitually resident in a single day. It will all depend on the circumstances, but I would accept that one may cease to be habitually resident in one country without having yet become habitually resident in another.
Can you give me the MS number again?
MS 2535, my lord. and at 2538. I'm sorry, volume 6, my lord.
My volume 6 seems to have disappeared in transit. Sorry.
I suppose when we're poring over all of these words in one case, we can bear in mind, of course, that the issue in A and A was not the issue in this case. It was a very different issue. And certainly the point with which we are concerned here didn't arise in A and A.
No.
So it's a limited value in
I
close textual analysis of what was said.
I see that, Milady. I've got to the stage of my submissions in relation to this subject where I'm dealing not just with our case, as it were, but also reunite submissions, which in turn may impact on the interpretation in our case. So that's why I'm looking at this, but I shan't.
I'm not trying to stop you doing it. I'm just trying to remind us.
Well, it may be that the next passage, which I take the court, establishes the sense in what my lady has just told me, which is paragraph 2538.
Page 2538.
I'm sorry, my lord.
Page 2538.
Page
You
2.
said paragraph. I thought we haven't reached that number. Paragraph.
Oh, there's always a first, my lord. 2538, page paragraph 54 in the list of principles or threads drawn there together by my lady. Number 7, the essentially factual and individual nature of the inquiry should not be glossed with legal concepts which would produce a different result from that which the factual inquiry would produce.
And then 8.
Lady, oh yes, 8.
My lady cites with approval the two paragraphs we've been looking at in the European judgment. Yes?
Yes, so A and A both, in general terms and there specifically, incorporates into domestic law that which is said in those two cases that we've looked at. And for completeness, if I may, re-LC, bundle 8, tab 102. Page 3291.
(3291).
My lord, yes. Tab 102. Now, this is the judgment of my Lady Baroness Hale and Lord Sumption, as opposed to the first judgment of Lords Wilson, Tilson and Hodge.
Well, no, it's the judgment of Lady Hale. I simply agreed.
My lord, yes. Paragraph 63 I was looking at, the following is stated: some habitual residences may be harder to lose than others, and others may be harder to gain. If a person leaves his home country with the intention of emigrating and having made all the necessary plans to do so, he may lose one habitual residence immediately and acquire a new one very quickly. If a person leaves his home country for a temporary purpose or in ambiguous circumstances, he may not lose his habitual residence there for some time, if at all, and correspondingly he will not acquire a new habitual residence until then or even later. And then these words, of course, there are many permutations in between where a person may lose one habitual residence without gaining another, which would, we would say, support the suggestion of my Lord Sumption a moment ago that there can be no test as to the frequency when these cases will happen. Sometimes there'll be a seamless transfer, sometimes there won't. It's impossible to predict, not least because it's only really the cases that come before the courts and which are then reported, which give us the sample from which to make that prediction. The court is invited by Reunite, however, to set out for the benefit of future judges and practitioners that it will be an unusual thing for habitual residents not to pass seamlessly. If the court wants to do so, of course, it must do. But the danger, if I may say so, is this. An expression of judicial prescience now runs the danger in 25 years of being debated over as Lord Brandon's predictions were 25 years ago. When the Supreme Court expresses views of that sort, the danger, quite simply, is that they are given exalted status over time and become, before you know it, a sort of test when being applied in the courts below. But I say no more about it than that. The point we make in our written case is, even if Reunite are right, that it is an unusual thing indeed for there to be a seamless transfer, then given that Mrs. Justice...
It'd be an unusual thing for there to be a seamless
I'm
transfer.
so sorry.
I think you left a knot out.
Yeah, not for the first time. The want of a couple of letters has let me down. It would be unusual, they say, for there not to be the seamless transfer.
Yeah.
In this case, Mrs. Justice Hogg found that it was the uprooting from England, the saying goodbye, the making the plans, etc., which caused habitual residents to be lost immediately on exit. We, of course, support that. If there was an error, it would be not to have appreciated that the second part of Lord Brandon's rule, as Lady Baroness Hale set out in that passage earlier, is no longer perhaps to be treated as such, and that at the point that it was lost in England, habitual residence in this planned context was gained in Pakistan. That would have, of course, no consequence on the other outcomes of the case.
Have you ever said that before?
Well, yes, in our written case.
That habitual residence was acquired by the 10th of February?
No, I'm not positively pushing that.
You're not?
No. I'm saying that...
I misunderstood you. I'm
My
sorry.
mistake. I've said that Reunite is stating the case too high in any event, for the reasons we set out, that it is simply just a factual analysis which will lead to one place or another. If the court thinks, no, it is only the very, very unusual case in which there is anything other than a seamless transfer, then applying it back to what Mrs. Justice Hogg found in this case, the result wouldn't be to keep mother and or child resident here. It would in fact be to suggest that though they lost it immediately, they perhaps gained it more quickly than Mrs. Justice Hogg might have thought. But I don't seek, of course, to disrupt myself, Mrs. Justice Hogg's findings in relation to residence. The second part of Reunite's case that I need to deal with perhaps is better looked at in writing rather than summarised by me. So in the core volume, in their case, paragraph 66, which is page MS 274, it says this, having set out the dangers, as they would put it, of a child being left without habitual residence. Following a unilateral move, unless satisfied that the child has gained a new habitual residence, Reunite submits that the court should ordinarily conclude that the previous habitual residence remains. The burden should be on the person who seeks to demonstrate that a new habitual residence has been gained.
As applied to abduction cases, presumably there isn't any... is there any problem in abduction cases about the absence of a seamless transfer? As I understand it, the effect of Article 8 of the Convention is that you look at the habitual residence immediately before the abduction anyway.
Oh, yes.
So that this is only a problem in cases like Lancashire County Council and T, which is not technically, I think, an abduction case, but it suggested an attempt to frustrate the process of the court.
Yes, I think Reunite would put it that the danger would be that if at the point that the child has no habitual residence.
Yes.
So in that interim period, they were then abducted. It may cause a difficulty.
I think you're right about that, Mr. Tyler. I think it's really, for example, a reverse snatch situation. One child is unlawfully abducted to a country in which, because of a limbo, he or she does not acquire habitual residence. If during that period there's a reverse snatch, then the Hague Convention won't kick in to be able to control and rectify it.
Yes. So that's the
How frequent a problem is that? I genuinely don't know.
almost.
A reverse snatch situation.
I'm not sure that's susceptible of an easy answer.
Right.
We would say that
There are other books full of such cases, or it must happen.
it must happen infrequently. We look at this with the words of Baroness Hale ringing in our ears that this simple factual concept isn't to be glossed over with legal principles. We say that what this actually would entail is the judge having to look, first of all, at country B to decide whether a child has gained habitual residence. If the child hasn't, then the judge will be asked by this court, if we unite a right, ordinarily to conclude that the previous one remains, unless the person seeking to demonstrate otherwise discharges a burden to demonstrate that it has been, a new one has been gained. It just makes no sense. It puts the order of events backwards. It creates a burden, that's a presumption, and then a burden that was never there. And it flies utterly in the face of the basic, the simple, what I called the only authentic principle, which is that this is a factual inquiry, which is to be focused first on state A and then on state B in order to reach one conclusion or the other. One may predict that if that sort of formulation found its way into a test or even simply guidelines from this court, it's simply going to lead to confusion at first instance and litigation following litigation.
Well, of course, it was a lot easier before we got rid of the you can't unilaterally change a child's habitual residence thing. So we are beginning to think through some of the consequences of that rule having gone.
But we are where we are, and to try to get round on a case-by-case or even a hypothesis basis problems that may arise by adding legal glosses, tests, presumptions, burdens, etc., is only going to make what ought to be a fairly straightforward scenario for the judge at first instance ever more complicated. And of course, this isn't just a question considered by High Court judges in the most serious cases. Habitual residence founds jurisdiction in all cases, in care cases, in private law cases. Magistrates, county court judges will be grappling with this without, we would say, it is to be hoped, the burden of that sort of gloss further put on it. And the danger is, as one set of glosses is swept aside, as Lord Brandon's ideas perhaps are consigned to a different era, the court replaces them with others which will in due course cause their own difficulties. But that, unless I can assist further, is all I intend to say about habitual residence. I'll move on, if I may, to parens patriae, to the inherent jurisdiction, and begin with a very quick review for a purpose which will, I hope, become clear, of the historical extraterritorial cases, which I hope needn't necessitate our turning each of them up. But in chronological order, Hope and Hope, 1854, it is for reference in Bundle 7, tab 90, a case decided by the Lord Chancellor, Lord Carnworth. The children had been wrongly retained in France by their mother. The complaint, it's important to remind ourselves, was technically brought by the children through their father as litigation friend. And two questions were faced by the Lord Chancellor. The first was whether the parens patriae jurisdiction could be exercised in relation to a child of a British national, so a British child, who had been born overseas. The answer provided was yes, it can be. Such a child is to be treated, quote, as a British-born subject, and one consequence of that, of course, is that he or she is, quote, entitled to the protection of the Crown as parens patriae. The second question posed was whether that jurisdiction can be exercised if the child is also overseas at the time. And that is the question to which the answer we know is yes. The Lord Chancellor describes himself as not having a want of jurisdiction. And in just a few short lines, really, the Lord Chancellor sets out why it is, with reference, in fact, to contracts being enforced, though they have their impact overseas, that the British courts' rule could extend that far. That's a passage, of course, where we read about the holder of the Great Seal entrusted by the Crown has the parents' patriae duty to all children, quote, under the Crown's protection, wherever they are. Now, that seems to be, from our researches, and all of our joint researches in this court and below, the first occasion on which it is definitively stated that the English courts can exercise the parens patriae jurisdiction in relation to children overseas. But it doesn't read as a landmark judgment. It reads very much as though it is virtually assumed by the learned Lord Chancellor that that is the case. The next case in time that our joint researchers have thrown up is Re Willoughby in 1885. That was the case in which the court concluded it had power to appoint a guardian in relation to a British child overseas. Guardian was necessary in light of the father's death, the fact of there being assets belonging to the child, and a pre-existing familial dispute. And that was the case in which Lord Justice Cotton described the necessity for extraordinary circumstances before making such an order. "50 years pass before the next case on the list, Re Liddell's settlement, in 1935, a case which involved the abduction to the USA by the mother in the case. That was the case referred to the court yesterday, where the gruesome Fulmen difficulty was contemplated, but clearly a case of abduction of a child. In 1949, the case of Harris and Harris was heard by the President, Lord Merryman. That was the case in which custody of children resident in New South Wales was in issue. An order had been made in New South Wales, and the father asked the English courts to exercise jurisdiction in relation to custody, control, etc. of the children. The President said that the court undoubtedly had jurisdiction to review the question of custody, though the British children were in Australia. But pausing at that stage, our joint researches have not thrown up any example of any case where an English court had acted simply to review the question of custody in relation to British children outside the jurisdiction at that point. And that research is echoed, in fact, in the Law Commission document that we looked at yesterday. That was the case in which Lord Merryman said it's the rarest possible thing for a judge of this division of the High Court to make a custody order in respect of a child who is out of the jurisdiction. That, we would say, is the case that falls very obviously on the other side of the line. If abduction of a child is a case which obviously is one in which a court, absent other possibility, would seek to invoke the jurisdiction to act for the child, this is one where it's very clear why that wouldn't be appropriate. The next case, always referred to but unusual, is the Sambach Justices case in 1950. That involved magistrates in Cheshire purporting to make custody orders in relation to children who lived in Northern Ireland. Lord Chief Justice Goddard, in that case, quoted the President, Lord Merryman from Harris and Harris, and said, in essence, if this is something that High Court judges do only exceptionally, it is not something that magistrates should be doing at all, let alone with any regularity. And so for that reason, they were found, the magistrates, not to have had jurisdiction. Whether that's a correct formulation or not isn't clear. But again, a case we would say that falls obviously on the other side of the line. Harben and Harben in 1956, Mr. Justice Sachs had to contemplate what to do in relation to the father who had kidnapped his children from Ireland to go to Jersey. I use the word kidnapped because his lordship used the word kidnap on several occasions. That's what it was. And his lordship said that whether or not this court makes an order in relation to a child outside the jurisdiction depends on the particular facts of the case. But of course, those facts have to be really exceptional before an order is made. Given that the children had been kidnapped, he said it would be wholly unreasonable for the mother to have to follow that. Then re-PGE, the Lord Denning case in 1965, involved a stateless child, but who had been living here, being abducted out of the country. And Lord Denning pronounced that the Crown protects every child who has his home here and will protect him in respect of that home. He also said, as for the child, he clearly has a call on the protection of the Crown because he was too young to protect himself. He had a right to the protection of the Crown, and the court will be familiar with the other similar expressions in that case. And that is the end of that line of cases. That brings us to FNS, Al-Habtoor, Reed v. Rien, etc. But pausing there, we note, as Lady Justice Black noted, that represents 7 reported cases in 110 years. Looking at the cases in which jurisdiction was exercised, they involved a clear abduction in clear breach of the rights of the custodial parent, except only for Willoughby, which involved the appointment of a guardian in relation to a British child. Lady Justice Black, paragraph 37, which is MS page 308, in this case at the court below. Having gone through the various cases, having collated the various different ways in which judges over the previous 100 years had described the way in which they would contemplate exercising the jurisdiction, said this: the other striking feature of the case law is the extreme rarity of reported cases in which the jurisdiction has in fact been exercised in such cases. Orders were made in, etc., etc. And at paragraph 38, her ladyship said, since those days there have been 2 important developments, and pointed first of all to the provisions of the Family Law Act, which we have seen, and secondly then to the accumulation of developments, if I can put it that way, which are described by Mr. Justice Ward in the FNS case. We would add to those 2 developments a third development, that is the treaties and statutes dealing with abduction since the days in which the inherent jurisdiction had to be exercised in the cases that I've set out. I shan't dwell on FNS, Al-Habtoor, Reed B and Rien because the court's been taken to them, will have read them. But if I may, we'll pick up on what was said about them by this court in A&A, which is in Bundle 6, tab 65.
So sorry, tab 1?
Tab 65, my lord.
65, thank you.
Now, firstly, we see at page 2520 in in the description of the argument advanced on behalf of the mother at the bottom of page 2520. Reference being made to the exercise of the nationality-based jurisdiction. Although the Court of Appeal, it was argued, declined to exercise jurisdiction on the basis of nationality in Al Habtoor and in Rien, on the supposed grounds that it was an exorbitant jurisdiction, that the modern currency of jurisdiction is properly habitual residence, and that if such jurisdiction still exists, it should be properly deployed in only the most exceptional cases. Any such gloss on the jurisdiction is inappropriate. What is important is whether the exercise of the power is necessary in the interests of the child.
Yes, well, what do you say about that last sentence? Would it be appropriate for us to say that this jurisdiction can and should be exercised when the welfare of the child requires it?
Not quite, Muller. I'll come, if I may, in a moment to what we say, where we say this.
Very well.
I certainly shan't neglect to
Thank you.
deal with that. But that was the argument that was before the court, explicitly, in that case. We see that those acting for the first intervener dealt with the question at page 2522, urging, in the last few lines of that passage before the next set of submissions is summarised, caution in exercising a nationality-based jurisdiction. Do so only if satisfied that the welfare of the child can't be protected by any other means. So a suggested test there higher than previously. And we know that Messrs. Setright, Queen's Counsel, and Gill, Queen's Counsel, made extensive submissions because my lady's judgment summarises them. So in the knowledge...
One's always aware that one never does counsel justice in one's summarising.
Well, counsel always think that.
Yeah.
The judge may be better placed.
No, the judge picks the things that she likes
Well,
or needs to deal with.
I'll remember that when I read this judgment, my lady. The matters dealt with by my lady, the question of the parents' patriarch jurisdiction. Where is it?
2548.
Thank you. At page 2540. I'm so sorry, 2539, that's perhaps a better place to start. Asking that section if there's another basis of jurisdiction, my lady sets out the Brussels II revised articles relevant to this, summarises Hope and Hope, sets out that well-known passage beginning with the reference to the holder of the Great Seal, sets out relevant parts from Lord Denning's judgment in PGE, referring to Willoughby, Sandbank justices, and the law commissioners in their report recognising the existence, but making the point I made earlier, which is there appears to be no reported decision in which jurisdiction to make a wardship order has been based on the allegiance of the child who was neither resident nor present in England and Wales. And then paragraph 62 deals with the more modern cases, Al Habtoor, Re B, and Re N, setting out, in a similar way to that adopted by Lady Justice Black, the relevant parts of those judgments. Importantly, we would say, although it's always difficult to tell the author of a document what she meant by the words used in that document.
That's a bit what I meant when I was talking about what judges say about counsel.
Yeah. But my lady says of Rien, in Rien, Lord Justice Macfarlane commented that, quote, if the jurisdiction exists in the manner described by Hogj, then it exists in cases which are at the very extreme end of the spectrum, close quote, full stop. The facts of that case, so my lady's words now, were certainly not such as to require the High Court to assume jurisdiction over the child in question. Now, Mr. Williams, Queen's Counsel, said yesterday that practitioners read this judgment, and I'll move to the rest of it in a moment, with the view that it significantly changed the exercise of the jurisdiction. We read it otherwise. In the knowledge that submissions were made about the test to be applied, and in particular it was put on behalf of the mother that the sort of tests, if that's what they are, the sort of comments in Al Habtoor, in B and in N, are inappropriate. The fact that my lady, in my lady's own words, confirms that the facts of N were not such as to require the assumption of jurisdiction, and the fact that those other cases are cited without any expression of dissatisfaction in the way in which the jurisdiction therein was exercised or not exercised, as the case may be, by the court, suggests that this court didn't feel that they represented an abhorrent change to the way in which courts were dealing with the question. Milady, at paragraph 63, sets out the absence of any doubt that the jurisdiction exists. Paragraph 64 summarises in the passage that we referred to the considerations that Mr. Setwright and Mr. Gill, Queen's Counsel, put forward as to why it's a difficult or problematic jurisdiction, inconsistent with, disruptive of the modern trend towards habitual residence, encouraging conflicting orders, etc. And then paragraph 65, we read, all of these reasons are reasons for, as Lord Justice Thorpe put it in Al Habtoor and Fotheringham, extreme circumspection in deciding to exercise the jurisdiction. Pausing there, and given that each of these phrases we keep reading, or none of these phrases we keep reading is put forward as being a definitive test, pausing there, we extrapolate from the judgment that this court was content with the way in which the jurisdiction had, to that stage, been exercised. There then follow 6 factors which my lady sets out, having said all must depend on the circumstances of the particular case. And he sets out, though it's not explicit, essentially to guide potentially the judge to whom the remitted, by whom the remitted hearing would in due course be heard. And at number 3, a factor seized on by the appellant, arguments as to forum are set out as being one of the number of factors which may, I emphasize the word deliberately, be relevant in the case. So question, does that of itself mark a change in the way in which the jurisdiction is to be exercised? And perhaps the broader question, and coming to the point my Lord asked a moment ago, what do we say about this jurisdiction? We say this, if one goes back, and of course one can go back far further, but if one goes back to Ward and Ward, as being the first case that we can find, which sorry, I mean Hope and Hope. So, yeah. If we go back to Hope and Hope to look at the first case we can find in which the jurisdiction is exercised in this way, it looks very much as though the Lord Chancellor was treating the jurisdiction as simply the parens patriae jurisdiction. The sovereign owes a duty of protection, that's the word used, to those who owe the sovereign their fealty. The first question the Lord Chancellor asked himself was, does this apply even if the British subject was born somewhere else? So to that extent, nothing unusual was occurring in that case. It was simply another question of where does the category of those to whom this duty is owned by Britain begin and end? Is it only British people born here, born elsewhere, what else? It's the next stage which perhaps is different, because it's the first time we see the Lord Chancellor expressing the view that the jurisdiction can be exercised, though the child be overseas. The Lord Chancellor didn't see that as being problematic, not least, he thought it no different to dealing with a contract question, any other question where the subject matter may probably be litigated here, but where it would require action overseas. We say that looking back to that stage, and looking back to the historical and legal basis of the jurisdiction, it is the right to protection by the Crown which founds the jurisdiction. Now, we know historically that since those days, the wardship jurisdiction, generally inherent jurisdiction, was extended little by little to enable the court to act in cases akin to private law cases now or akin to care cases now. The Law Commission report, of course, precedes the Family Law Act and helps us with the rationale for the Family Law Act. And if I may, I'll return to that, though we touched on it yesterday. My Lord Toulson asked yesterday about a fuller copy of that. We have provided a full copy. We're worried that there weren't quite enough papers yet generated in this case. I shan't refer to that now. I may, of course, note some paragraphs which we would recommend for reading if possible.
Are you going to give us a list?
Well, I'm going to look at some now that's in the bundle we have, and
Yeah.
of course I'll suggest some other
Right.
paragraphs if
Yep.
if I may.
Tab 23.
Thank you. So it's bundle 2, tab 23.
This is the same document as Tab Lewis, but only a bit of it, is it?
Yes, Lord, yes, sorry, yes.
It doesn't look as if it... Did you say tab 23?
Yes. I'm looking at page 1280. One sees at paragraph 2.7 a description of the wardship jurisdiction, beginning with the recording of its origin from the Crown's prerogative power, with the quotation directly from Hope and Hope. Moving on to talk of the duty of the Crown to protect those of its subjects who, on account of their tender years, are incapable of looking after their own interest, and that being delegated through the Lord Chancellor, through the various courts, finally residing where it now does in the family division. Paragraph 2.9 sets out that the primary object of the wardship jurisdiction is to protect those who owe allegiance to the Crown. Notes at the end, no reported cases where wardship has been based on allegiance of a child neither resident nor present in England and Wales. Turning to page 1285, paragraph 434.
The facts of Hope and Hope, as I understand it, the children were present at the time of the hearing. There had not been, the proceedings were commenced. Is that right?
Lord, I thought at the time of the hearing they were still in France.
The relevant children were still in France at all times.
Well, that's my understanding. But
I'm sure you're right. I've just forgotten what the details were. Thank you.
Paragraph 434 explains the Commission's proposals as being designed to replace the complicated scheme. And as we saw yesterday, the fourth line, designed to have effect on an international basis in the sense indicated, and to be exhaustive. At page 1286, wardship proceedings are referenced in the title before paragraph 441. At 442, nationality being a ground of jurisdiction in some other European countries is recorded. This basis of jurisdiction, it says, might therefore appear to be useful where the court of the country in which the child is resident or present either declines to assume jurisdiction over a British child or where it lacks the power to do so. Although British nationality is still a possible basis of custody jurisdiction under the English law, it's undergone profound changes, modifications it says. And the conclusion reached at the end of that paragraph is, furthermore, even where the child is a British citizen, it would seem that the circumstances of the case would have to be very special before jurisdiction was exercised on this basis. And the case of PGE is referenced in the footnote. Thus it was at paragraph 444 that the Commission came to the conclusion that they had little hesitation in rejecting nationality as a criterion of jurisdiction in custody cases. And two reasons are set out there. It didn't point to a fair and convenient forum, nor to a forum which could effectively enforce its order. And even more so, they thought a less definable concept of allegiance to the Crown in the absence of nationality was suitable as a basis of jurisdiction. So 446, for the reasons given, we regard both nationality and allegiance as unsatisfactory bases of jurisdiction in custody cases. It repeats other parts there. And at 447, one effect of our general jurisdictional proposals would be to remove jurisdiction from the High Court to make a custody order in wardship proceedings in respect of a British child who is neither habitually resident nor present in England and Wales. We don't believe a child has sufficient connection with England and Wales on which to found the custody jurisdiction. And that reads, of course, very similarly with the proximity criterion being given as the rationale for habitual residence in the preamble to the Brussels II revised. At page 70, so 1289, the emergency basis is described. And at 457, sets out the results of the proposal in the last 5 or 6 lines. The kind of case excluded by our proposal would be where a British child was in one of the Gulf states and not habitually resident in any part of the UK. His parents were not parties to divorce proceedings in any part of the UK. In that kind of case, we do not think that the intervention of a court in any part of the UK would ever be likely to be appropriate, whether in cases of emergency or not. So we pause there to contemplate then the Family Law Act, which the provisions of which I referred the court to yesterday, and to assess the intention behind them. The Family Law Act excludes jurisdiction in relation to any Section 8 Children Act order, except in cases of jurisdiction under Brussels II, Hague, or habitual residence or presence. And in relation to inherent jurisdiction, excludes jurisdiction to make any order so far as it gives care of a child to any person or provides for contact with or the education of the child. That's section 1(1)(d), page 846. The wardship...
Sorry, page what? MS
sorry,
page
it's
what?
page 846.
846, thank you.
Paragraph, section 1(1)(d).
B, did you say?
D.
D, yes.
So what is excluded by the Act? Section 1(1)(a), of course, deals with Section 8 orders. So the court couldn't make, as were, contact or residence orders, nor specific issue or prohibited steps orders. Section 8, a Section 8 order would be the usual means of making an order binding on a parent to return a child. Indeed, it was one of the orders asked for in this case by the appellant at the stage that habitual residence was contended for. It seems, we would submit to the court, that the Law Commission proposals and the Act which followed very clearly sought to delineate two different parts of the wardship jurisdiction. The protective element and that which had by then grown to deal with matters custodial, contact residence, but also where a child's to live, whether someone's to come back with the child, unless that is a matter which relates strictly to that child's protection. Because the moment that dichotomy is lost, the whole purpose of the Act is lost. If jurisdiction is not to vest to make Section 8 orders in relation to children abroad, but that a different jurisdiction, parens patriae, can be used to effect that return, and if effecting that return can be for reasons simply to create a forum, then what on earth is the point of this part of the Act? And that, we say, is why in F&S, Mr. Justice Ward uses the stark terms he does about devious entry through the back door of the court when Parliament has so clearly barred entry through the front of the court. We would go so far as to say that for that reason, forum cannot be a proper consideration when contemplating a return order under the inherent jurisdiction, though it may be, as has been set out, a byproduct. And if that assertion is correct, one that has to be assiduous in assessing the actual rationale for which such an order is sought. Coming back to this case, the submissions that were made by my learned friend yesterday, to start with, focused primarily on the need for there to be a forum, to be a court which could determine this child's welfare. When those submissions moved on explicitly to look at the return order and its rationale, the court was told that the reason for making the order was primarily for the child's welfare, that there were many, many reasons why England should be preferred to Pakistan as somewhere for this child to live, education, language, schooling, whatever else it was. Now, I'm not going to comment on whether it's right to make that sort of assertion at all, but I began my submissions yesterday by indicating a slight unease that a case by Supreme Court stage doesn't look exactly as it looked at first instance stage. And wonder whether...
They never look the same.
Well, no. But it's why
I think we said yesterday.
Yes. And it's why, if I may, I'm going to focus back on how it did look. So that those were the submissions yesterday, which set out a whole host of welfare reasons for return. Oh, and by the way, if that creates a forum, then all well and good, as far as the appellant is concerned. At the point of the Court of Appeal hearing, the skeleton argument at page MS 379, justifies return on this basis.
What page?
I'm so sorry, 379, my lord.
In which bundle?
Appendix 2. Paragraph 81. It's respectfully submitted that a return to this jurisdiction, either under Section 8 of the Children Act, I pause there not just for dramatic effect, but because of what I said earlier about the Family Law Act, Article 8 of Brussels 2 revised and or the inherent jurisdiction is consistent with the child's welfare and would facilitate the proper disposal of these proceedings so as to facilitate an inquiry and a resulting report by CAFCAS High Court team, ensure the mother's attendance and full engagement, and facilitate a relationship which the respondent has designed to deny the child with the respondent since that date. C, of course, is clearly a forum creating reason. A isn't a matter necessitated by or for which return is necessary, and nor, in fact, is B. Though she didn't come to the country, the mother has participated in these proceedings whilst retaining the right to deny the presence of jurisdiction. And so far as welfare is concerned, all the court is told...
Could this application be made without return? Would the court have any power to under the parents' patriae jurisdiction, based upon nationality, based on the fact that the child is a British subject? Is there really no jurisdiction which the English court could exercise in relation to the welfare of the child without return?
Yes, the English court could contemplate a parents' patriae return order without the child's return.
But I mean, is there a mechanism by which the English court could, for example, require a CAFCAS report or some equivalent report in respect of a child in Pakistan before deciding whether to order her return under the inherent jurisdiction?
Well, yes, certainly.
How would that happen?
It would happen either by the CAFCAS team speaking to the
Yes,
mother.
what would be the jurisdiction?
I say, well, it comes back to, there are two interrelated factors. Whether it would be possible to formulate proceedings, yes, it would. There would be a jurisdiction to contemplate making a return order under parents' patriae. You don't need the child present for that, ex hypothesi.
But I mean, it would posit, assuming that there isn't, this problem only arises if there's no jurisdiction on the habitual residence basis.
Yes.
Now, on that assumption, it would have to be said that the parents' patriae jurisdiction extended to requiring the mother to allow access to the child by some person who would report to the court. And that power exists under the parents' patriae jurisdiction, does it?
Well, the parents' patriae jurisdiction is limitless,
Yes.
save to the extent that that's been curtailed by statute.
Yes, I see.
It doesn't require return.
No.
I mean, the judge would say, would he not, Mr. Tyler, I am asked substantively to make an order for this child's return to England. I want to investigate this, and I want to make various collateral directions.
Yes, yes.
Including that the child in Pakistan be interviewed by somebody from what we used to call international social services.
Not quite.
Children and families across borders.
Yes.
They're now called, aren't they?
Offer was made.
And well, that offer, as I understand it, was made in this case
By
by the mother.
Where do we see that?
Under Moylan's order in July.
Mr. Justice Moylan's order in July, Miss Markham helpfully reminds me,
Reference?
I was going to try and find it.
the Appendix 3, my lord.
620.
620.
Which paragraph should we be reading?
We're looking at paragraphs 9 and 10.
Well, that was when...
Paragraph-
Coming here.
The hypothesis upon which we're asking these questions assumes the child doesn't come here.
Well, yes, paragraph 10.
Paragraph 9 is no good. Well, tell us what your present concession is then.
I mean, paragraph 10 appears to be ancillary to paragraph 9.
Yeah.
That's all to do with whether the mother brought the child back here voluntarily.
Well, paragraph 9 allows for an interview if the mother returns. Paragraph 10 is separate, doesn't require that, and provides for a report on matters of wishes and feelings and contact. And of course, there was a brief report from a CAFCAS officer, page 740.
Well, isn't that specifying what matters the CAFCAS team pursuant to paragraph 9 are supposed to report on? And it's not inconsistent with what you've said, but it doesn't appear to say so.
One would expect a direction to CAFCAS in those, if it was contemplated that inquiries would be made of the child in Pakistan, that the order would spell that out and spell out how it might be done.
Yes. Well, may I retreat from that position slightly, because I don't want to take a point that isn't justified. In answer to previous questions, it would be entirely permissible and not, in fact, very unusual for there to be some sort of welfare inquiry in relation to a child overseas.
We don't have any evidence about this, do we?
Not in this case, no.
No. And in fact, Children and Families Across Borders has not intervened in this case.
No.
Whereas they did in A&A.
Yes.
To my mind, it's an important point, however, because if we're going to decide the parents' patriarch jurisdiction, what strikes me as very strange is that you have a child who's a British subject, who's not habitually resident on this hypothesis in the United Kingdom, but it could be said that there's no jurisdiction for the court to make an order in relation to an investigation into the welfare of the child, for the reasons you spent most of this afternoon explaining to us. And to my mind, would be very bizarre, and it wouldn't be much of an extension, in my respectful opinion, to, in these days, to define the parents' patriarch jurisdiction widely enough, in order at least to take that step.
Well,
do you concede that or not?
Yes,
you do.
I don't even concede that would be an extension.
The submission was that the parents' patriarch jurisdiction is unlimited within its broad subject matter of the welfare of the child unless cut down by statute.
Yes.
And I don't think it suggested that it's cut down in this particular respect.
No. Where perhaps the reason for my hesitancy is because...
Well, what then is the reason for your hesitancy?
The reason for the hesitancy is because we say that whilst welfare, I'll come to this in a moment, is relevant to the question of return, it wouldn't be the sort of full investigation necessarily as though it were a complete no-holds-barred investigation into whether to make the return order. My previous submission is this can't be akin to creating a contact jurisdiction. So if the court needs the investigation
as to whether the welfare of the child required removal from Pakistan to England, rather than an investigation of whether the child should be brought into the English jurisdiction for the purpose of making a contact or shared residence order. Is that the point you're making?
Lord, yes, entirely. And after the word require, I would add for his or her protection.
I think I may have misunderstood some of your submissions. You stress so deeply the reference to the protective nature of the wardship jurisdiction. And although you didn't say it, I thought you were implying that the applications made by this appellant were not actually applications of a protective character. She wasn't saying this child is in danger and she must be protected. And for that reason, I thought you were saying we should put wardship on one side. But I've been misunderstanding you.
Well, I haven't I'm mid-submission, which is the difficulty. I am saying that it is a protective jurisdiction. I am about to say that this application got nowhere close to that, but on the general point, if a court needed, in order to determine whether protection was necessary, to have further inquiries undertaken, I don't say that the jurisdiction is so constrained as not to allow that to take place.
So this is an alternative, this is a fallback position.
Not
Your primary submission, as I understand it, is that the inherent jurisdiction isn't designed for this sort of thing at all.
right.
And alternatively, is this right? You say, but if we're determined to make it anyway, it should be on this basis, i.e. that there's a welfare inquiry.
Yes, I'm saying that this case, it is apparent from the face of it, is not one in which the jurisdiction could reasonably be exercised. If the court thinks, well, he's right about protection, but we can't be clear about that, then it would be a question for any judge to whom it was remitted to contemplate whatever further reporting or evidence might be necessary. I'd looked at...
But would that depend upon the nature of the protection? Suppose one of the respects in which it was said the child required protection was that she should have a substantial relationship with the appellant. Would that be a relevant consideration?
No, my lord, no.
That would be an irrelevant consideration, would it? Because of the statute.
Yes. The skeleton argument I just looked at, having compared that to the way in which submissions were put yesterday, the statement that accompanied the application for the exercise of the inherent jurisdiction application, I took the court to yesterday.
660.
It's at page
660.
MS 660 in Appendix Part 3. The paragraphs that explain the appellant's rationale, 8 and 9. 8 relates to contact and to the loss of contact. And then paragraph 9, right at the end, records what was said to be a worry and anxiety about attitudes towards homosexuality in Pakistan. Recording its being illegal, it was asserted under Pakistani law, not tolerated, and concern for the child's safety and well-being should the mother's sexuality be discovered. Now, the written submissions that accompanied that application, the final application for Mr. Justice Hogg, we looked at briefly yesterday, but in a different context. The relevant part is at MS 509. We'll see the paragraph 29, in fact, identical wording to the wording of the skeleton argument in due course, but simply asserting that return is consistent with the child's welfare and would facilitate disposal in the way sought out.
Well, I follow that's the application, but the point that I was canvassing was that that was wrong, that the court, perhaps accepting some of your submissions, is that one, it wouldn't be appropriate to, whatever happened, to direct the return of the child before, as my Lord Sumption put a few minutes ago, there was an investigation into the child's welfare, so that the court could subsequently decide what the right most sensible course was, having regard to all the circumstances, and at that stage, no doubt, some further grappling with the true construction of the Family Law Act might have to be focused on. But what goes against the grain is the idea that we could end up with a position, if your submissions are accepted in their entirety, that this child's welfare will never be considered by a court within this jurisdiction, and its common ground can't in practice be determined by the court in Pakistan. That's what goes against the grain.
Well, I don't accept either.
So you need to have, so if you want to win,
Yes.
right, you need to have something to resolve that problem.
Well, the child's welfare was considered by Mrs. Justice Hogg. It wasn't.
Now, you may have a point as to, you may have a reason for saying that on the facts one shouldn't do that, but as a matter of principle, you need to grapple with that.
Which part of Mrs. Justice Hogg's judgment were you referring to in that last remark?
Page 332. I think it sets out all the background at paragraph 33. Her Ladyship records the mother and her position, sets out that there's been no issue concerning her care of the child, no queries against her. It's not a question of the state intervening or even the applicant intervening to protect a child. Her Ladyship then deals with the only matter that was raised in the document I've taken the court to, relating to protection, which we say is the appropriate test, and sets out, in effect, that Her Ladyship is content that that is not, in the current case, of significance. And thus it is that the next sentence, at the beginning of paragraph 34, which is so railed against again by the appellant, isn't correct. There may have been...
saying that paragraph 33 is an appraisal of the welfare of the current circumstances of the child and whether those are for her welfare.
No, I was saying that that is a paragraph that contemplates whether there are welfare reasons, protective reasons, justifying a necessary return for the child's welfare.
Who would know? And how would the appellant be able to contribute to that inquiry? She knows nothing. The court knows nothing. And these days, Mr. Tyler, a welfare inquiry is attended by the voice of the child being heard, wishes and feelings, one way or another communicated to the court. Where do we have that?
Well, it doesn't have that. But, and I don't, the point I'm trying to make, I don't begin to pretend that this is equivalent to a judgment in a contact or a residence dispute taking place where the court has Children Act jurisdiction. That's when the welfare checklist, section 1, kicks in. That is when the court is obliged to undertake that inquiry. This is different. This is a parent wholly lawfully taking a child out of the jurisdiction in circumstances where the court's jurisdiction, though it would perhaps want to retain it, has been lost by action of statute. And the question is, in what circumstances should or could an English court, despite Parliament's decision, go against that, cause the return? And we say that the bar is such that unless a prima facie protective case is made out, the court need go no further. This judge heard evidence from the parties. I'll come in due course to how we say various international treaties impact on a child who isn't in the country.
While we've got this page open, could we briefly go to the next paragraph, 34, and go to the last sentence where Mrs. Justice Hogg says, in my view, had this been an application to relocate the child to Pakistan, there'd be a very good chance the application would have been granted, and if granted, there would have been plans, if not orders, for indirect contact. My question relates to the word indirect contact. Why did, in your submission, the judge consider that the relationship between the appellant and this child was so tenuous? Or why did the judge consider that the appellant represented some sort of a danger to the child, such that contact would only be indirect, Mr. Tyler?
I don't know, and the reason I say that is because, as I understand it, the judge asked the appellant in terms whether she would be prepared to travel to Pakistan to see the child. And as I understand it, but I'll check this, an offer was made that if and when the mother returned to the country, there would be no impediment to there being direct contact. So I can't account for those words because they don't accord.
It just looks like a complete downgrading on the judge's part of her appraisal of the importance of the relationship between the appellant and the child.
Well, my lord, I understand that. May I say this, and it comes again back to my point about how cases look. The relationship and its importance has been explained to you by leading counsel for the appellant. It's been explained to you totally differently by leading counsel for the respondent, completely differently. And the court, on reading various documents, expressed various views about that. But there is a judge, a High Court judge, who heard 2 days of evidence, who saw one of the parties, heard them both, got to know them as only the judge at first instance can do, and that led to those words, although, I'll be corrected if I'm wrong, those words possibly underplay what was potentially on offer available.
Thank you.
I mean, but perhaps that final sentence ought to have at least indirect contact, because of course in every relocation case, it isn't always possible for there to be direct contact, depending on location, means, physical stability, and so forth. So, my lord, my lady, we say that if one faithfully looks at the Family Law Act, and if one assiduously analyses what in fact this application was about, not least as assessed by the judge who heard it, and who heard counsel and the parties, it is an application for contact, and the return order is a means to create the forum for there to be that application for contact. No matter what one thinks in this case or any different case about the fairness or otherwise, Parliament has had the last word on when an English court can and can't make certain orders. And it's for that reason that in Al-Habtoor, in FNS, in this case, judges express regret that they don't perhaps achieve what they would like to achieve if everybody was in this country. But these are the courts of England and Wales. This is the jurisdiction in which they operate. And they don't, unless and to the extent it is proper, have a reach beyond those territorial bounds. We say, as Mr. Justice Hogg did, as in fact Lady Justice Black and the President did when they heard the case, that it would be an almost classical case of devious entry through the court's back door for there to be a return order in the current case. Now, I'm coming towards the end of my time, although I hope I may have the few extra minutes promised to me yesterday. Our skeleton argument, our written case, deals with Article 6, with forum necessitatis. We seek to add nothing to that in the knowledge that the court will carefully consider what we say about it, and ditto the question of psychological parenthood, which we address fairly fully in our written case. A final issue which has to be addressed relates to grounds 1 and 2 of the present appeal, which criticise the Court of Appeal for failing to act as it is asserted they were obliged to do in according to the child respect for her ECHR and her UNCRC rights. Now, I say at the outset of these submissions that we don't argue that the interests of the child aren't an important consideration in an application of this sort. We don't begin to argue that as a matter of common law, when courts make decisions about children, wherever they are, in whatever circumstances, the courts of this country will not take best interests as being important. We say, and I've dealt with this, that Mrs. Justice Hogg did do that. Where we differ from the appellant is in the suggestion that the Court of Appeal was under and Mrs. Justice Hogg, a binding international obligation to apply the child's European Convention and UN Convention rights in the current case. The skeleton argument deals with this in some length, but it's important, I think, just to set out why we say this. The case of Bankovic we refer to in our written case. Bankovic establishes, among other things, that the European Convention is territorial in its application. And to that extent, we rely on it. Though in subsequent cases there has been a change in relation to the concept of indivisibility of rights, it remains cited by the European Court of Justice as being good law to that extent. Now, Alskaney, which Lords may find at tab 30 in the appeals bundle, I don't intend to turn it up now, cites Bankovic with approval insofar as it establishes territoriality as the basis for the applicability of the European Convention, sets out a number of exceptions dealing essentially with consular or military action. This case falls into none of those. Smith, which is in the Air Centre Authorities bundle at tab 22, I will just, if I may, briefly turn up.
Still got 7 minutes.
And I shall look at paragraph 42 of Lord Hope's judgment, which is at page 113 of the...
MS number?
There is no MS number. This is the most recent bundle of authorities from the Air Centre.
What page is it?
It's page 113. Tab 22.
Olsen and Sweden.
Black bundle.
Black number. Second one.
Lord, I'm looking at page 113. In which, at paragraph 43, Lord Hope expresses the need for care when a national court exercises its interpretation of an instrument the correct interpretation of which can only be authoritatively expounded on by the Strasbourg court. The duty of national courts, it says at the end of the page, is to keep pace with the Strasbourg jurisprudence as it evolves over time. Lord Hope refers to Lord Bingham, making the point that Parliament didn't intend by enacting the Human Rights Act to give the courts of this country the power to give a more generous scope to the Convention rights than that found in the Strasbourg jurisprudence.
That statement directly contradicts what was actually said in Parliament by both promoters of the bill, but be that as it may. This is very familiar territory for us. We come at it time and time again in a great deal more detail than we're able to look at it at the moment.
Well, maybe quite. Lord Hope, in this case, Lord Brown talks of the danger of a national, there being greater danger in a national court construing the convention too generously in favour of an applicant rather than too narrowly. So, I end this point broadly where I began it. We don't say that the child's interests are to be signed to oblivion in a case like this, but we say that the presence of this child outside the territorial jurisdiction of the country and the non-inclusion in the case of the exceptions Alskini and other cases set out means that there is no obligation to afford to her European Convention rights. We make the same argument in relation to the United Nations Charter on the Rights of the Child, the Convention on the Rights of the Child. Article 3, we fully accept, and I hope appropriately so in our case, is applicable in the three different ways in which it can be applied almost universally in relation to this state's dealings with children, but only within the scope of the Charter, which is similarly territorial. So we say that those two grounds, on any view, can't be made out. That doesn't mean that my Lord's points about the voice of the child, the welfare of the child, etc., are not matters which domestically, at common law, this court or other courts in the jurisdiction wouldn't think important. But it does mean that any duty to do so doesn't derive from the instruments which are specifically pleaded as grounds of appeal, numbers 1 and 2. Now, I've barely touched on a number of aspects of our written case, but it isn't a short document, and we apologise for the fact that it doesn't take bullet point form. It's a prose document, which we hope explains our arguments in relation to those matters on which I haven't touched. Are there any other matters with which I can directly assist the court?
It would appear not, Mr. Tyler. Thank you very much indeed. Thank you. Ms. Markham?
Well, in light of the time, my lords, I follow my learned leader.
Thank you. Mr. Williams.
Lady, my lords, might I take that last point first, but very briefly, the extraterritorial effect of the Convention and the Charter. To say it is simply wrong, it is a straw man argument. If my learned friend is right, that the rights contained in the Charter and the rights contained in the Convention do not apply to B, because she is outside the jurisdiction, nor do they apply to his client. Nor do they apply to the respondent mother. Her Article 6 rights, do they apply? Her Article 8 rights, do they apply? If that argument were right, every left-behind parent in a child abduction case, their Article 8 rights would not be engaged and would not fall to be taken into consideration. In every immigration case, where the applicant is outside the territory, their rights would not fall to be taken into consideration. We have read the Air Centre submissions which focus on this point, and we would respectfully agree with those. The Human Rights Act itself, Section 6, which is in, I think, Authorities Volume 1, Tab 7, I think. Specifically requires by saying it's unlawful for a public authority to act in a way which is incompatible with a convention right if within these proceedings the court were not to take account of the Article 6 and Article 8 rights of all parties and were not to take account of the Article 3 Charter rights as incorporated within Article 8, it would not be acting compatibly within the meaning of Section 6 of the Human Rights Act. Of course, in this court itself recently, in the case of Smith, did look at this issue, and when my learned friend says that Al-Skaney confirmed the essentially extraterritorial nature of the convention, or the territorial nature of the convention rights, that is not actually reflected in the judgment of Lord Hope from paragraphs 45 through to 48, where he specifically identifies that Bankovitz is no longer to be regarded as authoritative on the point. I anticipate that this court has heard hours, days, weeks of arguments relating to these sorts of issues, and I don't want to take up this court's time with any further arguments on that point, but to turn back to some of the other issues raised by my learned friend. And can I start with the issue of protection, not just in the sense of parens patriae, but protection also as it relates to habitual residence, because habitual residence as the currency of jurisdiction does have a protective element within it, because it identifies for the child the state which is best placed to assess their best interests, and thus most likely to render a decision most congruent with those best interests. There's an irony, I suppose, in that the further one tries to whittle down the reach of the parens patriae jurisdiction, the more one promotes the importance of habitual residence being something which involves a seamless transition from one to the other, because if one doesn't have that seamless transition, one then does have children falling between the stools of two habitual residences, and there then being a question over how they are to be protected. This is one of the essential points made by Reunite in their invitation to the court to confirm that it is only in rare exceptional cases that a child will not move seamlessly from one habitual residence to another. And it is of a broader, the protection is of a broader nature than the reverse snatchback, as my Lord Wilson identified. It actually, in particular, has resonance in this case, but it has resonance for any case where a carer of a child, whether it is a grandparent, a step-parent, an unmarried father who hadn't acquired parental responsibility, where they will be left without remedy and where the child will be left without protection, if habitual residence can be lost as swiftly as Lord Brandon suggested it might be. It is in those sorts of cases, and it is a significant number of cases. Of course, I think this court dealt with the grandparents in the Northern Irish case, where a route to, as it were, protect the child was found through inchoate rights of custody. But there are many situations where the protection of habitual residence still remains a valid consideration. Not all cases will involve a retained jurisdiction under Article 10 of Brussels II or Article 7 of the 1996 Convention. There are still over 100 countries worldwide to whom those conventions do not apply and where this is an important consideration.
Can you just elaborate on that a little bit more, Mr. Williams? What actual cases involving grandparents and others are you talking about? Can you give us an example?
So grandparents who have been taking care of a child because the biological parents are for some reason unable to. There's 2 reported cases of Mr. Justice Peter Jackson, one of which involved, I think, the grandparents, where the child was then removed from their care, taken abroad, and the argument was made that the parent was entitled to do that. The grandparents had no parental responsibility, therefore habitual residence was lost as soon as the parent removed.
I see. Yes.
Mr. Justice Peter Jackson in that case concluded that habitual residence had remained here because the child remained integrated to some degree, notwithstanding their removal. So there are those sorts of cases. There are, of course, also the retention cases where Mr. Gratian tells me it is in the bundle. It's in volume 8 at tab 95, the case which I'm referring to. Retention cases are also a category of case where the retention of habitual residence itself in the country of origin is of importance in protection against abduction, because of course one has to assess habitual residence immediately prior to the removal or retention. If I can move on from the benefits to children in general and in particular of seamless transition of habitual residence to protection in the sense of the parens patriae. My learned friend Mr. Perkins appeared on behalf of the appellant mother in A&A in this court back in 2013, and at tab 65 the judgment of the court, which my learned friend has taken this court to in some detail. The arguments which my learned friend makes were almost all made when this court considered the matter in A&A, and this court ruled upon it. I'm not sure whether my learned friend is inviting this court to revisit the conclusions that it reached in A&A, but it occupies a substantial part of this court's judgment from paragraph 25 onwards through to those particular parts which deal with the parens patriae as to whether an application for an order for return is caught by section 11A or 11D, and this court concluded that it was not. And so whilst the analysis of the Law Commission report, and as it happens we also have the consultation paper or some extracts from the consultation paper which I'm not going to take the court to but will make available to the court. It's all very interesting, but this is a point that this court has adjudicated upon. In terms of what this mother was seeking in July, my learned friend suggests that the reality of the orders were not protective, and he suggests that the mother was not really interested in broader issues relating to B. Yesterday, the court was taken to the evidence that the mother put before the court in terms of her concerns, and that all appears in Appendix 3. And I hesitate to take the court to it all again, but for instance at MS 677 onwards in her detailed statement prior to the hearing before Mrs. Justice Hogg. The appellant mother set out all of her concerns. At paragraph 4, line 5, Zahara is a British national. It is imperative that she is returned to her home country where she has lived all her life, where her family live.
As you said, we've been through all this in your previous...
I shan't repeat it all, my lord, but that is the way the case was put. The problem that my learned friend focuses on is how Mrs. Justice Hogg then summarised that in paragraph 33, MS 332. Because when she said in that summary, which is said to be a summary of the welfare concerns that the mother had, of course it is a very, very incomplete picture when one compares it to the evidence that was before the court. And it is perhaps an indication of how this very experienced judge on this occasion simply got it wrong when she assessed this case at paragraph 34 as being one which, if it had come before the court in the form of a relocation application, would have had a very good chance of success. Well, an application by a mother to relocate to a country which she had not visited since she was taken there as a teenager and forced into a marriage there, and an application by a gay woman to take her child to a country where attitudes to the LGBT community are such as they are. Those two factors of themselves would suggest that this was, on any view, likely to be a highly complex relocation application with remote prospects of success. Lord Wilson asked where the reference to indirect contact came from in that paragraph. Well, of course, it did have a source. It was the respondent mother's own statement. Her statement, which was put before the courts at that stage, said that she was willing to offer indirect contact. And that, that particular reference is at page MS 646.
Well, as the hearing got nearer, she increased her offer, didn't she, Mr. Williams?
She did. Her starting
673. In addition to the indirect contact I've offered, there should be telephone contact. I'm also committed to offering your client, Mr. Williams, direct contact when we come back to the UK.
That's what
so I still don't really understand why the judge favoured only, or predicted only, an order for indirect contact.
It's difficult, I accept, my lord, to identify. It's at MS 646, the original offer was indirect contact, and as my lord rightly says, that did extend, but perhaps that's where another indication that the judge had perhaps not absorbed the totality of the evidence which was before her. Reference was made to the ability of the court to carry out welfare inquiries. Of course, there was a welfare inquiry contemplated, and the evidence in relation to the inability of the CAFCAS team to carry that out is at MS 741, where Miss Jolly of the CAFCAS High Court team set out the efforts that had been made to make some inquiry and her inability to do that. The ability of the court to make inquiries into the welfare of a child whilst in a country such as Pakistan, of course, is a thorny issue. My lady rightly recalls that in the A&A case, CFAB were an intervener, and at that stage were able to make an offer that inquiries could be made in Pakistan, that seems no longer to be the case, because having made some inquiries with CFAB yesterday and this morning, the list of countries which CFAB say they can conduct inquiries in no longer includes Pakistan. Perhaps I can just hand up that list. And the Kafkas High Court team themselves are unlikely to travel to Pakistan, given the potential dangers of doing so.
Does this affect the point that you made yesterday? You may remember you were asked, are you suggesting that there should be a return ordered anyway, or only subject to an appropriate welfare inquiry?
Yes.
You said it was the latter. Does the fact that Pakistan is not a place where Kafkas can operate affect your position on that?
Our primary case has always been that we seek the immediate return of B to this country. Right. We say that that was the right order in July 2014, and that the history since July 2014 has only strengthened the case for a summary return to this jurisdiction. The fact that it appears that it will be difficult for a welfare inquiry to take place with B in Pakistan, we say also strengthens that.
Well, difficult or impossible? I mean, what is the possibility in practice of Kafkas being persuaded to do this, or of some equivalent report being available from another source?
Well, the two
enough about the procedure to be able to even guess the answer to that.
The two usual sources, of course, would be Kafkas High Court team. They have, in some cases in the past, travelled to European countries. We're aware of one case where one of the caseworkers travelled to the Lebanon, but that was 5 or 6 years ago, and recent experience tells us that they don't travel to those sorts of countries to carry out inquiries.
So what are the alternatives?
CFAB would, in many cases, be able to provide an alternative, but they no longer cover Pakistan, it would seem. The other alternative is that B is returned to this jurisdiction for the welfare inquiry to take place here.
Of course, there's an intermediate position, isn't there, that this court could suggest what the relevant considerations were for deciding whether or not to exercise. We're talking here about the inherent jurisdiction in a case such as this, and send it back, firstly, for more evidence in relation to what we're currently talking about, and secondly, whether or not any such inquiry is practicable for a judge actually to address the welfare of this child.
Yes. I accept that, my lady. That, of course, is the sort of approach this court took in A&A, where it felt that further evidence was, or further consideration was required on the ground as to what orders should actually be made. In this case, we would say that this court can at least go a little further, in that this court should say that the jurisdiction should be exercised. It is just a question of what order should be made in the exercise of that jurisdiction.
You are inviting us to say that an order for the return to this country should be made in any event.
That is our starting point.
Right. And do you, in the light of the information you've just given us, have a fallback position?
Well, our fallback position is that which Milady has just outlined, which is that the matter would be remitted to the High Court for consideration to then...
Such evidence as can be obtained.
Yes, including consideration, of course, of whether the child were to be returned, as it were, on an interim basis to allow the welfare inquiry to take place without prejudice to her subsequent return to Pakistan.
And also for there to be further evidence filed, if need be, from the parties and from anybody else, and for a judge actually to ask the question, what's in the best interest of this child?
Absolutely, my lady. Is
The question has not yet been asked.
no. Is it in the best interest of Zahara to return to live permanently in Britain or to make her future in Pakistan? Of course, our primary aim in all of this is to persuade the court that the grounds in relation to the habitual residence of B are made out, and that when she left the country on the 4th of February, the day before the second mediation session, that she did not then lose her habitual residence, and that in the 10 days that passed between B leaving and proceedings being commenced, her habitual residence had not been lost, and nor had one been gained in Pakistan. If we succeed on that ground, then, of course, a far wider range of options is open to the court. And so the parens patriae jurisdiction in respect of B is, in that sense, a fallback position, but nonetheless a very important one. My lady, my lords, unless there are any particular points which the court feels I ought to address or needs assistance on in terms of understanding our case, I think I've run my course.
Well, your timing is virtually impeccable on both your parts, if I may say so. I'd like to repeat our very sincere thanks to everybody who's been involved in the preparation of the complex materials and arguments that we have had in front of us, for the hard work that they have put into it on a pro bono basis, for which the child and both parties should be sincerely grateful. The court undoubtedly is. Thank you.
Thank you.
We will, of course, attempt to provide you with an answer as soon as possible, but given the time of year, that may not be immediate. We shall see.
Thank you, my lady.
Court is now adjourned.